the head of litigation here at Winckworth Sherwood. We are a firm that's been around for 200 years. We've been specifically practicing in the area of banking law, certainly I have. And why me and why am I here representing Lloyd's Action now? Many years ago there was a case not too dissimilar to this one where I was acting for many hundreds of aggrieved victims of a banking scandal. The case had a life of its own which lasted almost 2 years, and one of the main and most important elements of that case was that we entered into what's known as a mediation scheme, and I'll talk about that a bit more later on. So I have experience in banking litigation, and I have experience in taking on big institutions such as Lloyd's. What is the case that we are actually advancing, and on whose behalf? There are two test claimants, two categories that we have certainly identified, which we'd like to put forward. I'm looking at these two test claimants as the ones with the highest prospects of success. The first test claimant relates to those who, on receiving the circular and prospectus, purchased further shares. Now, we all know that the information that was contained within the prospectus and within the circular was wrong, was inaccurate, and was half-baked. Relying on that information and purchasing further shares, in our view, is a misrepresentation which was advanced by the Lloyd's directors. The second major claimants are those claimants who actually decided, having either read the circular or prospectus, not to sell their shares and realised their value, and actually held on to the shares until the day when the actual news did come out, the proper news, the real facts that were sent out through the press. We all know that the whole thing collapsed, the share value collapsed, and Lloyd's, the banking group, was in a dire state. Now, those claimants have lost the opportunity to have realised those shares at an earlier date. So that's your second claimant. How do we want to try and resolve this dispute? Well, we're up against a huge institution with huge amounts of resources, who will, I'm sure, try to do anything they possibly can to try and kill this case dead. What we'd like to try and do is engage the politicians who, at the time of the merger, all publicly stated that Lloyd's shareholders were sold a lemon, were not given the full facts, and in the case of Vince Cable, taking on HBOS was a poison chalice. Now, they happen to be in government today, and we'd like to get their goodwill and do what's right for the country and actually stand up for what they believe is justice. With the politicians, with the actual bank itself, we'd like to try and engage them into some dialogue without having to issue proceedings. That doesn't mean we won't issue proceedings. It means we'd rather avoid it if we possibly can. It's happened before. We've avoided litigation. We've managed to engage with the powers that be, and we've managed to settle amicably without too much fuss, too much trouble, and too much time. Two things that must be certainly at the forefront of your mind. Will we win? And if we don't, will we suffer adverse cost consequences? Well, will we win? I'm sorry, but I can't say either way. What I can tell you is this, that we have a very good team of professionals around us, and we are going to give it our absolutely best shot to try and achieve a settlement, and a reasonable settlement on your behalf. We believe there are good prospects of success, but once again, in any litigation, we don't know what the end result will be. We don't know how Lloyds are going to actually fight this, whether they are going to throw millions and millions at this to try and destroy us, but we hope not. Will you suffer adverse cost consequences? The position there is we will not issue proceedings and let that clock start ticking, whereby there will be adverse consequences against you, until we are properly funded. Now that funding could be either through insurance. In other words, we will engage with insurers to take out a policy which covers any adverse cost consequences, should there be any. The other way is for us to have adequate funding in our own accounts, whereby if we were to lose and if there was any adverse consequences, we could cover it. Therefore, you don't suffer. You pay your subscription, you pay your fee in terms of how many shares you have, and that's it. Will we be making a demand for further payment? The answer to that is no. Finally, what we'd like to do is invite you to join Lloyds Action Now. The reason for that is that without you, we can't take this forward. If you'd like to sit on the fence, well, that's your prerogative, but if this case is going to succeed, it will need strength in numbers. It will need you to step up to the plate. We've been working on this case for 18 months to try and get it to where it is today. We've had good publicity, and no doubt we will have bad. Of course, we know who's going to be behind the bad publicity to try and destroy Lloyds Action Now. But if you feel that an injustice has been done, if you feel that you have genuinely been taken for a ride and bailed out the country, bailed out the economy, bailed out the banking system, then you need to stand up and be counted. And that's entirely in your hands. As far as we're concerned, we're standing up to the plate. We're not going to go away. We're going to see this to the end, and we need you to join us. Thank you.